Good afternoon. I'll be arguing for the appellant Rashid that his conviction be overturned based on the following facts. The appellant did not receive his Article 6 rights to a fair trial, and the judge erred in denying him special measures for the entirety of the trial, not just when he was giving evidence. The judge, accepting that the appellant was of low IQ, erred in concluding that the appellant had no significant mental impairment despite expert evidence, and concluded that the appellant did not need an intermediary for the whole trial, so as to help him understand and participate in his trial. The Court of Appeal supported that the judge was right to have only awarded the appellant an intermediary when giving evidence. This was based on his judgment of Rashid's educational background and his own observations, thus concluding that there was no significant impairment of the appellant's mental vulnerability. The judge failed to consider Dr. Hathaway's expert evidence that the appellant had an IQ of 70, which was below average and would have had trouble understanding large quantities of information and would have benefited greatly from an intermediary in his trial. By only awarding the appellant an intermediary when giving evidence, the judge did not consider how the appellant, who the experts had ruled did not fall under the Mental Health Act of awarding special measures for vulnerable defendants, was still mentally vulnerable and could have had better understanding of the prosecution's evidence by awarding an intermediary for the whole trial. The judge had ruled further that a competent advocate and guidance by a judge is enough to ensure a fair trial. The prosecution took the view of R.V. Cox, where the significance of an intermediary was put to question, concluding that a trial is not based on the use of intermediaries. The trial judge played the part of an intermediary, which was supported by the Court of Appeal, which was of the view that the trial judge had played his role sufficiently well and that an intermediary is merely a desirable and not a necessary measure. The greatest danger in making Cox a working and binding precedent is although it may have been sufficient to allow the judge to assist the defendant on this occasion, on other occasions it may not be. By depriving the defendants of using an intermediary is a breach of the Article 6 rights to have a fair trial. Furthermore, according to the Law Commission's paper in 2010, the court set too high a threshold for finding a vulnerable defendant to be unfit to plead. The court seemed to be actively denying defendants the use of intermediaries by this high threshold, and this is a breach of the defendant's rights to Article 6 of a fair trial. This applies to the case of the appellant, as the fact that the courts denied the use of an intermediary by concluding that the appellant was not significantly impaired shows the high standards for vulnerable defendants. The principle of accurate fact-finding by Roberts and Zuckerman should have been upheld, as should Rashid have been able to understand and participate in the trial, he would have been able to accurately rebut any other relevant evidence. With the criminal procedure rules, the court is required to take every reasonable step to make sure that the active participation of everyone involved in the trial. This is supported by the criminal practice directions that this will enable a defendant to give their best evidence. If a defendant wants to give evidence in support of himself, they should be allowed to, and the court should facilitate that. R.V. Great Yarmouth Youth Court was a landmark decision that the intermediaries could be provided for the whole trial, including giving evidence if there's a small risk of the defendant not understanding the proceedings. Rashid, being a person of low IQ, had his mental vulnerability compared to someone who needed an interpreter. It is in my opinion that the court should have followed the principle of R.V. Great Yarmouth Youth Court of awarding an intermediary for the duration of the trial, so as to make sure that Rashid would have been able to understand the proceedings, as there was a large risk of him not understanding the proceedings. Even though it is rare for a defendant to be awarded intermediaries for the trial, a large majority of defendants are denied this, and according to Prisons Reform Trust, about 7% of adult prisoners have an IQ of less than 70. This would mean that many other prisoners could have potentially been denied the right to a fair trial under Article 6. This is very worrying. The Youth Justice and Criminal Evidence Act shows the clear difference between the special measures available for a vulnerable witness for prosecution versus the special measures available for a vulnerable defendant. The use of an intermediary is easily available to the vulnerable witness versus a vulnerable defendant. To combat this, Section 104 of the CJA has recently included a provision which allows vulnerable defendants to give evidence with an intermediary, but it has yet to be implemented. By not actively implementing this provision shows the court's unwillingness to comply with the parity principle and thus increasing the inequality of arms between the Crown and the defendant, creating an adversarial deficit. Should a defendant be granted the use of an intermediary, it is often a non-registered intermediary rather than a court-assigned registered intermediary. In OP versus Secretary of State for Justice, the appellant had been granted a non-registered intermediary for the duration of his trial. The Secretary of State's denial to use the registered intermediary to the defendant, even though it was submitted, that the defendant risked receiving a substandard service from the non-registered intermediary. The reason for this appeal relates to the differences in the training and supervision between a registered and non-registered intermediary. The High Court was of the opinion that an individual tried for a serious offence should be entitled to have a registered intermediary so he can give the best evidence for himself. Registered intermediaries are perceived to provide better and superior services and should thus be available to vulnerable defendants who qualify for intermediary use. The quality of help received is also very different. As seen in a journal article by Emily Henderson, a very valuable tool, the non-registered intermediary is a lot more expensive than a registered intermediary and less experienced. The fact that a vulnerable defendant is already at a loss of his implied right to effective participation of his own trial under Article 6 calls for change. This means that Rashid should have had an intermediary for the trial so as to make sure that the principle of equality of arms is upheld. The provision of intermediaries for the defendants was first approved by the Court of Appeal in RVSH. LJK found that an intermediary should have been allowed to act in a role equivalent to an interpreter when the defendant is in the witness box. In the case of CV 7 Oaks Youth Court, it was ruled that the cost of funding an intermediary is the court's responsibility, as the legal aid agency points out that an intermediary is not a form of representation, but to enable a defendant to communicate with the court, and thus equivalent to translation, and therefore should be funded by the court. It is almost as if you and I were tried at a court that spoke Chinese and were only awarded an intermediary when giving evidence and not for understanding what was going on through the trial. It is unjust and goes against our right to a fair trial. It happened in the case of Rashid, as the judge did not allow him an intermediary for the entirety of his trial. In the case of RVSH, it was found that the judge, under common law, possessed the power and discretion to provide an intermediary. Consequently, in the case of the appellant, the judge should have had exercised the same discretion to rule the same. The judge should not have used his discretion to watch the PACE interview and disregard the medical evidence provided about the appellant's vulnerability. In the case of the appellant, the judge using his discretion to ignore medical evidence sets a precedent for other judges who can disregard medical evidence based on their own observations, which makes the trial highly prejudicial against the defendant. Regarding the competent advocate, the Lord Chief Justice went on to say in R.V. Rashid that a competent advocate of the court would be, in the rarest of cases, be able to ensure that a vulnerable defendant can fully participate in his trial without an intermediary. However, the court must take into consideration that representing mentally vulnerable defendants requires a specific training, and only some advocates have taken that training. Furthermore, the court should also consider that the other arm of law that should be competent enough to identify vulnerability, the police. The court should impose more in-depth training onto the police so that they can be better equipped in identifying suspects with mental vulnerabilities. In the case of Rashid, Lord Thomas ruled in support of the trial judge in refusing an application for an intermediary for the entire trial because he had considered all relevant matters, including the scarcity of intermediaries and other resources. He was of the view that intermediaries are expensive to the public and it should take a lot of consideration in deciding if a defendant should be allowed to use an intermediary. By letting costs of intermediaries come between the pursuit of justice and the right to an appellant in having a fair trial, it is almost as if the court is picking and choosing who has the right to have an intermediary instead of letting the Youth Justice Criminal Evidence Act (TJB) define whether a mentally vulnerable defendant is able to have the right to a special measure. This is unfairly subjecting a mentally vulnerable defendant to some kind of hidden test that is prejudicial. Denying the appellant an intermediary for the whole trial just because it was expensive is a breach of his Article 6 rights to a fair trial, as it is the court's responsibility to make sure that fair trials are conducted. Article 6 is a fundamental and crucial right that every person is entitled to. With Brexit coming into effect next year, the government needs to make sure that the UK does sign a post-Brexit deal with the EU to remain a part of the ECHR, as it will be binding on the UK. Without the ECHR and Article 6, it is very worrying what will fill up the gaping hole in the system for the defendant, as one parliament does not bind the other. In conclusion, for the courts to be publicly perceived as a fluid legal engine by abiding Article 6 of the European Convention on Human Rights is of utmost importance. By not allowing the appellant to use an intermediary for the duration of the trial is a violation of that right. The courts need to be seen as consistent in redressing the adversarial deficit and making sure that there is equality of arms and keeping with the principles of accurate fact-finding. Therefore, it is in my opinion that the appellant Yahya Rashid should be allowed to use intermediaries for the duration of his trial and while giving evidence, and his conviction be overturned. Thank you.